Judiciary Committee on January 26th, continuing our testimony on H89. And this morning, we're going to be hearing from a few witnesses. After we're done with the witnesses, we'll probably have more time, and we'll probably have Michelle Childs come up and kind of review where we are right now as far as going over any changes that we've identified so far. But we're going to start with Dr. Erica Gibson. And if you could please identify yourself for the record and tell us who you're associated with and proceed with your statement.
Sure. So good morning, Chairperson Lalonde and Vice Chair Burdett and members of the House Judiciary Committee. I'm grateful to all of you for the opportunity to be here today to show my support for H89, an act relating to civil and criminal procedures concerning legally protected healthcare activity. My name is Dr. Erica Gibson, and I am a pediatrician with a specialty in adolescent medicine. I currently serve as the Division Chief of Adolescent Medicine at the University of Vermont Children's Hospital, where we run several adolescent medicine clinics, including the weekly UVM Children's Hospital Transgender Youth Program. Today, I'm speaking not only as a physician who provides direct care to youth and families, but also as an official representative of the University of Vermont Health Network, a member of the executive board of the Vermont chapter of the American Academy of Pediatrics, and as a member of the Vermont Medical Society. In April 2021, as attacks on youth gender care began to escalate in both public forums and state legislatures, the Vermont chapter of the American Academy of Pediatrics, UVM Children's Hospital, the Vermont Medical Society, and multiple other Vermont healthcare organizations released a comprehensive memo that addressed the importance of the provision of thoughtful, comprehensive, developmentally appropriate, family-centered, gender-affirming healthcare as recommended by evidence-based healthcare guidelines. That memo reiterates the fact that every major medical organization in the United States recognizes the medical necessity of gender care for improving the physical and mental health of gender diverse people. We have submitted a copy of that original memo along with this testimony. Unfortunately, as I speak to you here today, almost 2 years later, numerous other state legislatures have passed or are attempting to pass discriminatory laws that aim to prevent young people and families from accessing appropriate gender care, and also seek to penalize gender healthcare providers for providing this care. To quote a pediatric colleague of mine who testified against one of these bills in Ohio, these bills are an extreme rejection of safe and effective medical treatment for a vulnerable group of youth, and they enact barriers that would cause families irreversible harm and ultimately cost lives. In addition, these discriminatory laws in other states place my pediatric colleagues in the ethical dilemma of refusing evidence-based care for gender dysphoria or face loss of medical license or criminal charges for providing this care. We are thankful that the state of Vermont has remained steadfast in support of gender diverse Vermonters and their families and the care that we provide to them. I would like to acknowledge the important joint resolution that was passed by the Vermont legislature in June 2022 to support transgender youth and their parents who seek essential medical care for the treatment of gender dysphoria. At this time, in a mounting crisis of child and adolescent mental health care, it is essential that gender diverse youth and their families, that care for gender diverse youth and their families is protected, and that the providers providing this evidence-based care are protected also. We've heard numerous stories about the frustration and fear that our colleagues are struggling with across the country. In states where this care has been outlawed, some providers are watching rates of depression, anxiety, self-harm, and suicide increase before their eyes, while they are unable to provide the vital health care that their patients and families deserve. In other states, providers are stepping down from important positions at highly respected academic medical institutions because the state political climate will not allow them to provide the evidence-based care that they have been trained to provide. In all states where discriminatory legislation is active, hundreds of providers are taking time to present testimony alongside youth, families, and allies in order to provide the facts about the importance of this care. And as a result, many are suffering private and public verbal and physical threats from opponents. In addition, many of the specialists in this field have been prevented from traveling and speaking at important international clinical care and research conferences due to direct threats to their own safety. And anyone that provides and supports this care routinely receives both veiled and open assaults on their personal and professional intelligence and competence through direct and indirect messages assailing their clinical acumen and training. This bill will provide crucial protections for healthcare providers and expand the ability to safely care for young people and families that seek evidence-based, legally protected healthcare in our state. We thank you for your commitment to the health and well-being of anyone seeking healthcare in Vermont, and on behalf of our patients and families and the multiple medical professional organizations that I represent here today, we respectfully ask you to pass this bill. Thank you.
Thank you very much. So questions, I assume you're available to take some questions. I understand that you have to be out by about 9:30. So
that's correct.
Okay, great. Questions? Barbara.
So I know yesterday in testimony, one of my colleagues asked about suicide rates, and I'm wondering if there is any information from your colleagues in other states in terms of if levels of suicide or suicide attempts have increased, and or other sort of bad consequences, and if you're able to share any of that information or get that data for us?
At this point, there are no published research studies with that specific data that has been collected yet. So all the information is anecdotal at this time, but it's an emerging area of research. There is some research in the psychological literature that came out, I think 2 studies this year out of the University of Florida that relate to parental interviews about fears about the results of this damaging legislation and the fear of increased rise in anxiety, depression, suicidality on the part of the parents for the young people they care for, and also on their own parts because they also suffer greatly. So I think that's unfortunately, if this continues, that data will emerge, and I think it will be quite clear.
And is the National Academy of Pediatrics also, have they taken a position?
Oh, yeah, absolutely.
Okay.
Mm-hmm.
So
we cite them in our memo,
okay.
Yeah.
All right, thank you.
Karen.
Yes, excuse me. Thank you for being here. This came up in conversation yesterday that we had around data protection, and that could be an opportunity for us to include more in the bill around that. Curious if you have thoughts on that, if that's an area of concern from your perspective.
You mean access to confidential medical records?
Yeah, or even I think it was that's one person said of being able to like buy data of who is accessing services or who provides services, that type of thing.
I don't know that I can comment specifically on that, but I would encourage as much data to be protected as possible, whether it's regarding providers' care and what kind of care they provide, or of course, the confidentially protected data of patients.
Other questions? So I have a couple questions. So with respect to the SHIELD bill, it certainly mitigates risks for providers. But as far as, there's not full protection, obviously, if providers travel out of state, for instance, or if they, this is already the case, practicing without a license in another state, obviously, even through telemedicine. But how do you anticipate the word getting out to make sure that providers do understand what we're trying to do as far as mitigating those risks, protecting folks in Vermont, but having an understanding that there's limits as far as what we're able to provide as far as protection?
Well, luckily, as a small state in which I would say almost all our medical providers are very well connected to the Vermont Medical Society or their individual national or state organizations, we are able to come together and provide education and guidance in a routine manner and actively do that on many things at this point. So I think once everything was sorted out and clarified, there would be a large effort in that way to provide guidance and education. In addition to individual organizations like UVM's Health Network and our own departments where folks are working in affiliation with academic medical centers or hospitals, that would all. We also have to follow the guidance of the organizations we work for, right? In addition to our Vermont Medical Board and recommendations. So.
Okay. Also, if you could just tell me how give you a current or give you a kind of a scenario, and just if you could tell me how gender affirming services are provided in this kind of scenario. If we have a Vermont resident who is getting gender affirming care here and then goes to college and say at University of Alabama, I mean, how does that continued care occur? Because I understand that with gender affirming care, it's not like a one-stop such as reproductive health care often can be.
Yeah, good question. So young people who live in Vermont but travel out of state to college usually maintain both their primary care and specialty care at home, right? So I have college students who I care for as a primary care physician and provide gender care to, and they see me when they're home for summer break or winter break to check in. But all universities do, the larger ones do generally have their own university and college health services where young people, through whatever mechanism that university has created, can seek primary and specialty care at their universities also. So it's possible that someone might seek ongoing gender care at their university if they needed to be seen more frequently or certain things needed to be monitored. But I know already with the rise of these discriminatory bills, parents and families are already figuring out which states they would never send their young person to college in because of the risks of being in a state where their rights to this protected health care would not be protected. So this really has a lot of far-reaching implications.
Right. Thank you. Kate.
I just want to take an opportunity before you have to go to just thank you so much for the work that you do in Vermont. I'm a queer person myself and a therapist, and I live in a rural community, and so I've become a person that a lot of young people get referred to who are queer and trans identified. And I can't tell you would think in a small state like Vermont and in a rural community that would be a small number of referrals, and it's really not. It's pretty significant, and I've interacted with UVM quite a bit, and you guys have been really amazing, and it's a tremendous service that you offer to families and youth in our community, so thank you.
Thank you so much. I just want to clarify that I work with a whole team, and there's a whole network of providers in the state of Vermont that are increasingly providing this care. So we're really lucky at this point, and lucky to have skilled mental health providers like yourself out in the community who are equally as important for support if it's needed. So thank you also.
It's not an exaggeration to say that it really does save lives in our state. So thank you.
Definitely. Any other questions? All right. Well, I appreciate your time, and hopefully we'll catch you sometime down in Queen City Park when I'm walking around knocking on doors in the future. So I really appreciate it.
All right. Thank you for your work also. I appreciate you taking the time.
Thank you.
Take care.
All right. And before we turn to Jessa, just a quick update. Karen, you raised the question about data. And I think that actually the Senate bill, the companion bill, does have some stuff in there about data. So you probably want to take a look at that. And so that seems to be somewhat covered. And I also understand there's probably a big data protection bill in Congress that may have some overlap with some of the issues we're talking about here. So
Great.
So that is happening, and we probably are not going to need to deal with it so much except in the context of quashing subpoenas and the like. So just want to give you that update. So we'll go to Jessa Barnard of the Vermont Medical Society, and if you could identify yourself for the record and your association.
Absolutely. Thank you. Good morning. I'm glad I could be here in person, and it's my first time meeting you all this session, so thanks for the opportunity to be here. My name is Jessa Barnard. I'm the executive director of the Vermont Medical Society. So we're the state's largest physician and physician assistant membership association. I'm also here this morning on behalf of some of our specialty medical societies. So those represent various sort of subspecialists in medicine. So that's the Vermont Academy of Family Physicians, family practice physicians, the American Academy of Pediatrics Vermont chapter, so our pediatricians who care for kids, and the Vermont Psychiatric Association, who represents psychiatrists. And all of our organizations are strongly in support of H89. We collectively represent approximately 3,000 physicians across the state, and our members provide both primary care and specialty care in a range of settings. So we're across setting types: hospital-based, federally qualified health center, private practice, and also represent the full range of reproductive and gender-affirming care services that our members provide. And our members have reviewed and strongly support the findings of leading national medical associations that you've already heard referenced by Dr. Gibson this morning, that comprehensive reproductive health services, including access to contraception and abortion, and the provision of gender-affirming care, are the standard of care in medicine. They really are evidence-based practices. Based on those guidelines, in the past couple years, we've established policy positions as an organization here in Vermont, supporting access to contraception, abortion, and gender-affirming care. And we work to support the passage of Prop 22 and on the work of this body to advance protecting those rights here in the state. And we also, as with some of the other witnesses you heard yesterday, support including both of them together in this bill. We think it's really important, and sort of share some of the earlier testimony you heard that both are similar. They're similar in that they're both evidence-based, but both increasingly politicized around the country and deserve protection. And I won't repeat, I know you had great testimony yesterday. I was not here in person, but I was listening to all of it, and it was very informative to me as well. So I won't repeat it all, but just echoing our concerns about the attacks around the country on both forms of all of these services, and the limitations on access to abortion, reproductive care, and gender-affirming care that's happening across the country. And also the fear and uncertainty that these laws are providing. I think you heard both from Ledge Council and some of the other witnesses, the variation across the state and how quickly these laws are changing and being modified by courts, legislatures, public referenda. So it's very hard as a provider, certainly in those states, but even trying to provide care to patients who may be traveling here or via telemedicine, to know if what you're doing is currently legal, accepted practice or not. And so I think that increases the need for protections like this, because there could be a provider who thinks what they are doing was perfectly acceptable in the state where a patient's located, and then a week later it's not. So it's a very uncertain time for medical practice and for law in these states. And a new form, and these laws are really testing our understanding of areas of civil liability. I think you heard some good descriptions yesterday of SB 8 from Texas. So kind of citizen, almost bounty laws, they are innovative, they are new. And so to even know the extent of how far they're going to go, or things we might have thought, I think, again, you heard this yesterday, might be sort of far-fetched examples of liability, kind of following a provider to another state may no longer be so far-fetched. So again, for all of those reasons, and what we're hearing about patients already needing to travel and continuing to travel outside their home state to obtain necessary healthcare services, we believe this law is both needed and very helpful. I won't read it, but I did include in my testimony, actually pretty much as soon as the leaked Dobbs decision came out, we started talking to lawmakers about this sort of area, about a shield law. And we actually had some conversations in the spring about, do we try to stick something, get something through before the session even adjourned. But as you also heard, this is also a new area, and other states were passing similar protections through executive order or legislative action. And there was kind of a feeling, let's wait and see kind of what shakes out. Let's learn from some other states. And I think now we have some really good models. And we support basing this on the Massachusetts model, which we know this is largely modeled after. I've had some conversations with my sort of counterpart at the Massachusetts Medical Society, and they were very involved in drafting and reviewing the law and supported it there as well. And so our organization in September passed a policy statement supporting a shield law, which outlines the provisions we would want to see included. And between your draft and the Senate draft, we think it really does cover the needed areas of law and really pulls from what it seems like is kind of gathering best practice from the different bills around the country. And I want to just highlight a couple areas we think are particularly important. We think the new cause of action regarding tortious interference with legally protected healthcare activity may be an important both deterrent and then also the ability to recoup legal expenses. Again, I don't even think we really know the full world of liability that may come out of this. And so the ability to, I think there certainly will continue to be risk to some of the questions earlier. This doesn't solve all of the problems. And so since there could still be suits or risk, the ability to then recoup legal expenses and fees could be very important for healthcare professionals. The other area I want to mention is the protections for address and personal information. I reached out when we heard this might be in the bill to some of our OB/GYN members, and they were strongly in favor of this. I included a quote from one who provides abortion services, who gave examples. She says she was trained early on never to put her home address on any medical license applications because those could be made publicly available. Many providers buy their houses through a trust to avoid property record disclosure. And any efforts to reduce the private addresses of healthcare providers in any field is absolutely critical to supporting and protecting the workforce. So thank you for thinking of that opportunity and including it. And we do really support including that. I made a note to mention, so I really appreciate your comment this morning about educating providers about kind of the extent of these protections. I think that's a really important question, and I've been thinking about it. I mean, obviously, I think the state is doing the right thing, kind of balancing what might be constitutional versus what we might wish in an ideal world to be able to prevent any liability. And so I think there are going to be a lot of, I think it's going to be difficult to navigate. And I think this bill is not intuitively understandable to a healthcare provider. So certainly as a professional association, we're committed to educating our members about it. I also think we would look to partner, whether it's with legislative counsel or with the licensing boards on just some plain language kind of explainers, what this does do, what this doesn't do. Certainly that's not quite the same thing as legal advice, but probably not a surprise to you all. Many small healthcare providers do not have attorneys, don't have easy access to attorneys. So it's not as if they can all go get individual legal consultation. So I think the more we can do, the more you can do as a body, the more the licensing boards and professional associations could make sure there's some kind of plain language translations of what this actually means.
So before you move on.
Helpful, yeah.
So I don't think that's something we can really necessarily have legislative counsel directly deal with, but is there an entity? I mean, because that's one thing we could potentially add here is to direct an entity to provide, we'll figure out the best way to put it, but plain language as far as this is concerned.
So I hated to do this because I've not talked to these individuals. So I always hate to put people on the spot, but I did notice you had Lauren Hibbert from OPR coming later this morning. So, they with the OPR and then the Board of Medical Practice are certainly the two entities who license all healthcare providers and do tend to send out a lot of educational they send out information to their licensees when laws and regulations change. For example, last year there was a lot of change around telehealth licensure, and they have great, OPR, for example, and Board of Medical Practice have great links. So, are you providing telehealth? Here's what you need to know about our current, how to be licensed in our state or other states. So I think those entities,
So that's OPR.
Office of Professional Regulation under and the Board of Medical Practice, which is under the Department of Health. I think it's related to the Senate bill too, the pieces around discipline. So they're already going to be involved. I'm sure I imagine they will already be testifying on that bill. We've been in touch with them about those components of the bill. So I would suggest those are natural channels to at least share information. And you're right, I wasn't suggesting that legislative counsel do education as much as, that I think they often do wonderful summaries of bills, even for your purposes as well. But that's what I was suggesting, if there was a clear summary that then we could work off of to make sure it can be, to help educate.
Yeah, when bills are enacted, there is a summary that
Yeah.
State Council does.
Yeah, exactly.
But
Yeah.
the question is whether, and we can ponder this, whether we actually direct OPR or the Board of Medical Practice to provide those guidelines.
Yeah.
So we can ponder that.
I think that could be helpful, especially again with combining with the companion bill, dealing with a lot of licensure issues, and especially the area I will say that gives me the most concern about understanding what can be protected and not is the telehealth piece. I mean, we have, as much as we have over and over, we tell our members, this current standard of practice is that you need to be licensed in the state where the patient is located. Then that all got tossed in the air with COVID. Most states waived all that for COVID. So now we're going back to that world, but some states have still telehealth licensure rather than full licensure. I mean, it's very complicated. And again, for a provider who, here's the scenario that comes up a lot. You have a Vermont patient. They are your patient in Vermont. They're on vacation for a week. They call you. Do you even know where that patient's located? That patient's on vacation in South Carolina. If you ask them where now people hopefully know to ask, but if you don't ask, you may not even know. You may think they're in their bedroom, but they're in a hotel room somewhere. And technically, to comply with the law, you are supposed to be licensed in South Carolina now to answer their questions, prescribe them a medication. So that's even without the shield law. But then you add on the shield law of saying, well, some things may be protected, but we still can't as much as we might want to. I think this bill makes the statement that they're protected regardless of where the patient is located. I think the question is, will that state where the patient is located agree with that? Tennessee, to pick a state, will I imagine argue no. We say we regulate the care via telehealth where the patient's located. And, Vermont may say that they can protect this, but we may say no, we can still. Our laws govern. So that could be an area. I think that is an area I anticipate could have that will have to play out in the courts, and that the provider may still have there may still be liability that attaches to that.
Right. Yeah. For practicing for public license being the issue we talked a little bit about yesterday. So the licensure issues as well that you mentioned. As far as for telemedicine, presumably will be taken up even more in depth in the healthcare community, I would think, as far as that kind of issue.
Well, the problem is Vermont can't change that standard. So what Vermont can regulate is a healthcare provider outside of Vermont wanting to provide telehealth services to a patient in Vermont. We can say, you do or don't need a license for that. And in fact, the healthcare committees did great work last year saying exactly that sort of thing. We are going to make a limited, much easier, less expensive telehealth registration system. So you want to follow your patient who's skiing in Vermont and has a question, we'll make that easy for you. But Vermont can't do the reverse. So we're pretty limited in terms of what sort of protections we could create in that scenario. So yes, the healthcare companion bill is looking at professional disciplinary repercussions of that, but we can't actually change the telehealth standard itself.
I don't know if I stopped you mid.
I would think I was pretty much wrapping up, just saying thank you for taking up the legislation. Continue to look forward to working with you on the bill, and we really appreciate this work. We think it's very important. So thanks.
Questions? Karen.
Yeah, I feel like you've touched upon this a little bit. I'm just trying to understand the current landscape of providers in either of these areas. It seems like it probably is a little bit like, okay, we're figuring out if the shield law goes, like there would be one set of things. But are we seeing are more people coming in to provide? Are people actually leaving because they're not feeling if you can give any sense of what does that landscape look like, and how do you see the shield law affecting it?
From what I have heard anecdotally, health professionals in Vermont feel much more protected and grateful to be in Vermont than most other places in the country right now. And that Vermont's kind of affirmation that these are fundamental rights and protected services is great. I think the remaining issue is what the Shield Law gets at, which is more patients. I believe there is, and actually I know Lucy from Planned Parenthood will be here later, I think has data on this. I think we are seeing more patients traveling to Vermont for some of these services. I think, so that's the area of question. And then I think the telehealth piece is kind of the piece of question. So I would say providers are not leaving Vermont. If anything, we hope maybe it will in fact be an attractive place for providers to come to provide services. You heard from Erica, people really can't practice the standard of care in many of their home states and are so anguished over it. I mean, the scenarios they see their patients coming, life-threatening situations that they cannot legally safely address. And that is putting them in a situation where they entire maternal fetal medicine departments at academic medical centers who provide, helping people conceive are leaving, because then if there's a fetal anomaly, problems with the pregnancy, a woman in a life-threatening, coming in literally, having a needing miscarriage management, they can't address those situations. So they are leaving. And not that that's a horrible situation in those states. Maybe we'll get maybe some people will come to Vermont because of it and help with our workforce issues. I would say that, at this point, that's anecdotal. We haven't really seen that play out, but I don't know if that answered your question.
It doesn't. I just feel for our Vermont residents that we are very fortunate that we have this whole continuum of care.
Absolutely.
And that folks feel provided and protected in order to provide that care.
Yes.
So, you raise a good point, because I think when we look at who's moving to Vermont, a lot of people are moving here because, medical providers aside, because people want to live in a state that shares some of their values. So there might be a horrible silver lining in it, but I'm wondering, and I don't know if this is a question for you, but if we need to look at other protections for medical providers who actually choose to relocate here, like if that is a different situation.
I think the one piece that I know I did see in the Senate bill does address, for example, is saying if you've been disciplined or licensed in another state for providing protected health services, then that can't be taken into account for licensure or relicensure in Vermont. So I think that's an example of, say they, that's an example of that. I don't, off the top of my head, I don't think I have other.
So I'm just trying to think about I'm sure in those states, people can't get medical malpractice insurance. And I don't know if there's anything with having something on your record that shows had trouble getting. So just trying to think holistically about obstacles that might stand in the way of bringing qualified providers here to do the work they want to do and need.
Yeah. Another issue addressed by the Senate companion bill. Malpractice, so not being able to adjust malpractice rates or deny malpractice insurance. So good thinking. I agree.
Read that bill.
Okay.
But if you think of other examples, absolutely, we'd love to. We'd love to work with you on any other ideas like that. Yes, fully support that.
So I guess I will ask one other question, and then Ella. But is there anything missing that? It sounds like not, but
I didn't see, and actually I had a great, very helpful crosswalk from the American Medical Association, kind of looking at all the executive orders and state laws so far on the books that have addressed these issues and kind of chunking them into what areas have been addressed. And the best I could look at, but between this bill and the Senate bill, I did not see anything missing. And nothing came to mind other than, this piece about the educational piece. I think we all need to kind of collectively think about how we make sure healthcare providers understand and know about the law, assuming it goes into effect. But I think they are quite comprehensive. They included some pieces, the piece around the protection for access to healthcare facilities, I think is really important. I'm really happy to see on the Senate side some language around crisis pregnancy centers, which many of these other laws haven't addressed, at least in the same bill. So I think there are some great pieces between the two bills, and I at this point can't think of anything missing.
Great. Ella?
Thanks for being here. In the definitions section, you would have heard some conversation about this yesterday if you were able to listen to all the testimony, which I know was a lot. Part of the definitions is that legally protected healthcare activity does not include any service rendered below an applicable professional standard of care or that would violate anti-discrimination laws of this state. Can you speak to whether you feel, like my concern is that so broad that it's going to get some practitioners into a situation where maybe, some state is claiming they were, either operating without a license when they didn't think, like places where professionals think they're doing the right thing and are following the standards of care, but somehow they're not. Can you comment on if you think there's a risk here, or if we should be more narrow in our description of what we're trying to avoid, which is trying to avoid supporting physicians who are not in malpractice situations? Right.
I know it's a fine line, because I think we don't want to be protecting folks who are truly not meeting the standard of care. Honestly, I think I actually see this playing out almost more in some of the discipline situations in the other affected by the other bill, but it certainly could be at play here. I think there would probably have to be a process in the courts to determine if that was indeed the case or not, right? There could be a debate over whether they did or did not meet the applicable standard of care. If it's the scenario I came up with where, the law changed a week ago, I think probably certainly disciplinary boards, I don't know as much about courts, would say, well, that was the standard of care until a week ago. So even though you were practicing without a license and that's not the standard of care in Vermont, you thought you were you thought you were meeting the standard of care. Again, I think there's some of this bill that's going to have to be a little bit of a leap of faith that we're doing our best, and that maybe we'll learn more in the next year or two and have to come back and fine tune based on actual cases we see, hopefully in other states, not in Vermont, or thinking of the scenarios. I mean, I think it will probably be virtually impossible to draft something that addresses every hypothetical out there. But I think this is a very thoughtful and important first step. And we could always, if we learn of scenarios where it's not working as intended, certainly could bring that back to you.
Any other questions? Thank you so much for being here. And,
absolutely.
As we proceed with the bill, if there's any kind of changes that come up, we'll reach out to see if you need to come back in or submit any additional written testimony.
Perfect. Thank you.
I really appreciate your time.
Thank you. Thanks for taking up the bill.
So we'll go next to Lucy. And if you could identify yourself for the record and then proceed.
Yes, thank you, Chair Lalonde. Thank you for having me here today. Good morning. My name is Lucy LaRiche. I'm the Vice President of Vermont Public Affairs at Planned Parenthood Northern New England. I want to express my gratitude to my representative and lead sponsor of this bill, Representative Donnelly, and to its many co-sponsors, and to this committee for taking up Bill H89, and for your leadership in doing all you can to protect patients and healthcare providers in accessing and providing care in Vermont. PPNNE is the largest reproductive healthcare and sexuality education provider and advocate in Northern New England, with health centers in Vermont, New Hampshire, and Maine. There are 7 Planned Parenthood Northern New England health centers in Vermont, and last year we served 16,000 patients in our state. Our services include abortion services, birth control, cervical, breast, colorectal, and other cancer screenings, erectile dysfunction treatment, follow-up services for abnormal pap tests and HPV, infertility workup, miscarriage care, trans-inclusive healthcare, including gender-affirming hormone therapy, STD testing and treatment, and prevention services, and well-person checkups, and more. Since the Supreme Court overturned Roe v. Wade last June, bans have eliminated access to all or some abortions in 18 states. More states could implement abortion bans this year. The consequences of these bans have been devastating for both patients and providers. And the effects of these bans are not limited to states where abortion is no longer legal. In Vermont, Maine, and New Hampshire, where abortion is protected, we have seen patients traveling long distances to access care. The harmful effects of abortion bans stretch beyond abortion care. It's now harder for people to get life-saving medical care for miscarriages, ectopic pregnancies, and other pregnancy-related complications. Providers and medical staff in states with harsh consequences for people who perform or assist in abortions are afraid to treat patients, even in emergency situations. That puts the health and lives of pregnant people at risk, as providers are forced to delay urgently needed procedures until people are dangerously sick, so they can legally provide care that meets the definition of life-saving to ensure compliance with restrictive laws. We also know that anti-abortion rights lawmakers won't stop at banning abortion. They're working toward a broader agenda to roll back our rights and freedoms, from access to affordable birth control and to LGBTQ plus healthcare and more. I'm here today to express PPNNE's appreciation and support for this bill that aims to protect providers and patients, regardless of the patient's location, from legal repercussions for offering and receiving essential and sometimes life-saving healthcare, including reproductive healthcare services and gender-affirming healthcare services, both of which Planned Parenthood provides. This comprehensive bill aims to create protections through a number of provisions that include limitations on arrest, testimony, extradition, summonses, a judgments provision, privacy protections, and a countersuit, as well as ensuring access to healthcare facilities. I am also fully in support of the provisions in the Senate bill that will add additional depth and comprehensiveness to the protections that this bill is offering. We deeply appreciate the inclusion of gender-affirming care in H89. Across the US, there are continued attacks on transgender rights and gender-affirming care. In 2021 alone, state legislatures across the country introduced more than 100 bills to restrict trans rights, with close to 60 of these bills amounting to healthcare bans for trans youth. This trend continued into 2022 with more than 150 anti-trans bills introduced, about a third of which would limit or entirely ban minors' access to gender-affirming care. Providers and patients in Vermont should be able to continue to navigate a healthcare system without harassment or fear. Last November, Vermont voters overwhelmingly passed the Reproductive Liberty Amendment, which now protects reproductive rights in our state constitution. Vermont voters stood up for reproductive freedom for ourselves, our neighbors, and future generations. And every Vermont town gave majority support to the Reproductive Liberty Amendment. The amendment protects the rights of every Vermonter, no matter their gender or identity, race, where they live, or how much money they have. H89 is a natural expression of the values asserted by Vermonters in November about protecting the dignity to live your life and be who you are without government interference. It's about protecting healthcare providers who deliver compassionate care every day. This bill aims to mitigate the risk of out-of-state enforcement against reproductive healthcare providers in our state who provide care, including abortion and gender-affirming care, to patients from our state and elsewhere. We also know this is a new and untested legal landscape. So as not to create a false sense of security, we will continue to advise our healthcare providers to seek legal counsel and information and education to ensure they fully understand their specific risks. Given the hostile environment nationally, it is critical that our state take every available opportunity to protect access to this care for those in our state and for our neighbors forced to travel away from home to get necessary time-sensitive care. This bill is an important step to ensuring that abortion and gender-affirming care remains accessible in Vermont. We're proud to live in a state where our elected leaders are eager and determined to ensure that people can safely access abortion and gender-affirming care, and that providers can continue to offer this critical care with protections from legal harassment. We hope to continue working with you to increase access to care this legislative session and for years to come. And that's it. thank you if you have questions.
Thank you very much. Questions? No? No questions? So there was some data that was suggested that you might have. And I can't remember what it was.
Jessa Barnard from the Vermont Medical Society's testimony just referenced some data about patients who might be seeking abortion care or other kinds of health care in Vermont who might be coming from a state where abortion is banned. And since the Dobbs decision, since the Roe was overturned in June, our organization, our affiliate, has seen about a 10% increase of people seeking care from other states. And it's a broad range of states, including Texas, Ohio, Alabama, North Dakota, and other states, Florida. And it's really interesting because you would expect that people would simply just go to the next nearest state. But there was a case, for example, and just an anecdotal little story, a woman from out west, I think it was Nebraska, decided that she went on this long road trip and she drove through all kinds of states that provided reproductive health care, abortion care, but she felt safest coming to Vermont. And so she drove that extra distance to make sure that she was in a place where she felt safe and comfortable. So people will travel to other states for all kinds of different reasons. Sometimes there's a support or a family network, friends, some other resources in another state. So so much of this landscape now is completely unpredictable.
And how is your organization keeping up with that increased demand for the services?
We're a mission-driven organization, and we have, despite the fact that we had to close some health centers in last year about this time, we have increased our telehealth services. So we do offer medication abortion through telehealth. And that's something that we are widely promoting, and I think has been really successful and helpful. And we're also really grateful that insurance will reimburse for medication abortion through telehealth.
So I would assume as well that part of the reason people feel safe in Vermont is what we've already done for protection, and I would assume that even more so once the SHIELD law is put into place, but hoping that more and more states join this and have the SHIELD laws. Could you tell us what your understanding is of other states that, I think we have heard some of that testimony, but other states that we're expecting to see movement on SHIELD laws over the next year or so?
Yeah, besides Vermont working on a SHIELD law, I know Oregon is also working on one. There might be one other one that I think
Illinois is what I remember here.
Yeah, Illinois.
So,
Illinois is one.
Other questions? Angela.
Hi, good morning, Lucy.
Good morning.
You mentioned that you're addressing the increase in demand for care through increased use of telehealth, including medication abortion. Has that been strictly within state boundaries?
Yes. Thank you. But thank you for asking that. That's a really important question, a really important clarifier. We are not offering telehealth services to people seeking abortion out of state. This is a service that we're providing only for people who are physically present in the state of Vermont. It could be someone from a banned state, but they have to be physically present in the state of Vermont.
And a follow-up question: what sort of proof do you require that they are physically present in Vermont? What's their burden of proof?
That's a great question. I don't even know. I would have to ask our healthcare provider. I think it may be asking the question. In addition to that, maybe providing an address, a physical address, and then checking that. But I'm guessing, so that's something that I can confirm with our healthcare providers.
And so that is just.
And I'll just add that most of the patients that we see from out of state tend to be coming in for surgical abortions, because we also know that one of the problems with bans, abortion bans, is it forces people to get the healthcare that they're looking for, that they need, late. It delays care, which really puts them beyond the 11-week window where we provide medication abortion. Their pregnancy, the gestational age of the pregnancy beyond 11 weeks is automatically has to go into a surgical abortion, an in-person procedure.
Gotcha. And just one more question.
Go ahead. Any questions if you want.
Your the medication abortions, is that being done through prescription versus, we've heard stories of pills mailed to folks, but I'm just confirming that you're doing this through prescription writing.
Yeah, we can self-prescribe. In other words, we have prescribing authority, and we actually have those medicines on hand in our health centers, and we actually mail them ourselves to make sure that everything is, so that we can have that control over the entire process.
So mailed to a Vermont address if you're
Correct.
Okay, thank you.
Okay.
Hi, Lucy. Thanks for being here. I was curious, one of the sections of the bill that folks have highlighted and sounds like are excited about is the provision around protecting people who are trying to enter buildings where they're accessing healthcare. And when we've talked about this kind of policy in the past, there tends to be some kind of tension around like, well, aren't there already laws on the books that sort of could be utilized by healthcare providers if they need to? We don't really need this provision necessarily. I guess I'm just curious if you can share in your perspective why that provision of the bill is helpful to you and the work that you all do.
Yeah, thanks for the question. It is really important. I'd like to just give you an example. In Brattleboro now, in the Brattleboro Health Center, we're getting regular visitors from the Massachusetts College who buses up students and a couple of professors to stand on the sidewalk in front of the Brattleboro Health Center to try to intimidate and harass patients who are trying to access care at that health center. They peek in the windows and prey at people. So this hasn't really been a problem in Vermont up until recently, until the Supreme Court had taken up the Dobbs case, where I think abortion rights have become even more politicized and amplified in the press. In addition to that, since that happened, since the Supreme Court took that up, we have seen vandalism in a couple of our health centers. And this is also really new for us. We haven't seen vandalism in our health centers since, in the recent past. This is a relatively new thing. Williston and Barry, both health centers were vandalized. In Williston, someone threw a big rock through a large waiting room window. And in Barry, there was writing, graffiti all over the place on our sign and on our door, and actually on the siding of the building itself of the Barry Health Center. So the provisions that you outline here for access are incredibly important for us because they also require, or they also allow for damages so that the perpetrator can be fined. And I think having some kind of teeth like that is the part that I'm particularly appreciating, because I think it could act as a deterrent for violent acts in the future.
Appreciate it. Thank you. So I think you would have already told us this, but I'll just make clear and ask the question. Is there anything missing or anything you think that would help improve what we have in front of us now?
What I love about this bill is that it is so comprehensive. I mean, between this and the Senate companion bill that deals with medical malpractice data and licensure, those things combined with this bill, I think are really great. And I think, in fact, this bill does go beyond what a lot of other states' shield law bills have done. I can also appreciate that we can't do everything that we really want to do within this bill because of constitutional limitations. But I just really appreciate this committee and the legislature digging into the provisions to try to figure out how far we can possibly go. I think I just wanted to also sort of add to Jessa Barnard's testimony, affirm or to agree with something that she said also about the definition of a patient, regardless of their physical location. That provision concerns me a little. The other thing I wanted to just flag, I know that you had Patience Kosier from GLAD in yesterday. I just want to also make sure that diligence is done around vetting the bill with the LGBTQ community. I think, just as an extra protection, maybe some more conversations there just to ensure that particularly some of the definitions are good. And also there's a judgment in the judgments provision. I know that there's, interstate child custody cases with LGBTQ folks that, and I'm not an expert in this area at all, but it was flagged for me. And I just wanted to raise that here since I have the opportunity.
I'd love to hear a little bit more about that last item, the interstate child custody. If you could define what that issue is. Yeah, so I'm not sure I fully understand it, but what I think this is about is when it has something to do with reaching into other states and denying judgments. Because in the case of custody battles, for example, between gay couples, there has been this has been a battleground around making sure that a state maybe that is friendly to LGBTQ rights, and where the person, but maybe one of the people who got a judgment in that state is now living in a state where it is not friendly, that is or is not honored. I mean, I guess there's been a lot of there's been a lot of back and forth and concern about getting courts to honor judgments in an interstate way for LGBTQ couples. And I hope I'm not just completely butchering the issue, but I just maybe get somebody in here who actually understands this. Right. It seems like that possibly goes beyond the scope of this bill, but I could see that as another area that expanding some shield law protections could be necessary, and we'd have to delve in a little deeper to whether there's any avenue to not give full faith and credit to such a judgment from another state, and it's fairly narrow circumstances that we can't. So we'd have to figure that out. Any idea who else we might talk to about that? Yeah, so I can find somebody. Yeah, okay. I think certainly our national office can direct me in a direction. We can certainly talk to the LGBTQ Alliance, the Pride Center, maybe Kate. I know that this is an area where Representative Donnelly, this is an area where you have activism. Maybe you have contacts or ideas as well. Okay. Happy to dig into that a little more with my networks. And if we can back up, you said there was a concern about the, and this is really on page 5 of our bill, the idea of regardless of the patient's location. If you could explain your concern, you said that you have some concerns about that provision. Yeah, my concern is it's more around creating, first of all,
when we, as Jessa Barnard from the Medical Society described, someone's license, a health provider's license is specific, it's specific to a state or a group of states or more than one state where they have a license. When a patient is in, the example she used was South Carolina, and the provider is in Vermont, and there are restrictions to abortion or gender affirming care in the state, in say South Carolina or Alabama, providing that care and the abortion, we just don't want to create a situation where the abortion provider thinks they're safe because of the shield law, because they're not.
Right.
And having that language in there might, just a high level read, an intuitive reading, a provider might think that they're safe to provide care to someone in South Carolina when in fact they're not. And I think also for, the shield law and the others, of course, downside to the shield law, the protections are largely for providers. And it's sad to me that the legal construct of our world, it doesn't really provide an avenue to protect patients more. But that's the other part. I don't want patients to feel a false sense of security either.
Right, and that would certainly be part of the educational component of this. I do believe, and I can get confirmation as well from legislative counsel, that part of the reason for that provision is to make clear for choice of law that if a case is somehow brought into Vermont, we're going to make very clear, no matter where, as long as there is some connection to Vermont, that it's going to be Vermont's law that will apply. And I can get confirmation that that's in part what we have this for. And there may be other issues in the other bill where this is important to have that language in there. But I understand what you're saying, and that is definitely part of the educational component once this gets put into law.
And I do love the idea of having OPR involved in some kind of translation for medical providers. It is a complex group of provisions, I think, and maybe difficult for a layperson to understand. And I think that would be a fabulous addition to the bill.
Appreciate it. Other questions? I think we're good. I really appreciate your time. And as I have told other witnesses, if we're going to be making changes over the next week or so, certainly we'll reach out to see if you have any additional comments.
Wonderful. Thanks so much. Thanks for having me. Thanks again for all your great work here.
Thank you. And I think we'll take a short break now to stretch before we have our final witness, and then have Michelle come back in to kind of go over what we've learned so far and what kind of additional drafting may be done.